Is calling 2024 CR 2594, State of Texas versus Mark Anthony Perez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense. And are you Mr. Perez?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with injury to the elderly, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes. Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. State recommends community supervision. They're taking in consideration County Court Cause number 731618. There's an affirmative finding of family violence, TAP evaluation, follow those recommendations, mental health evaluation, and follow those recommendations, and no contact with Juan Perez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes. Yeah, yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yeah, yes, Your Honor. I understood that.
Did you understand that to be the entirety of your agreement?
Yes. Yes, Your Honor. Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. Did you understand those are recommendations from the state and the court does not have to follow that recommendation?
Of course, Your Honor. I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State law for states 1 and attachments.
No
Any
objection,
objection? Have you spoken with the complainant?
We had spoken with the complainant, Your Honor. Yes.
All right, you may continue to confer.
Thank you, Judge.
You're welcome. Mr. Perez, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor. Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, we'd like to, Judge.
Anything you wish to say on behalf of your client?
Alright, pause right here for a second because this is where the stakes become very real. The judge just laid out the charge: injury to the elderly causing bodily injury. That is a third-degree felony in Texas, which means this case is not small at all. We are talking about a possible prison sentence, so right now the defendant has to decide whether to risk a trial or move forward with the plea deal, and trust me, that decision can change someone's entire future.
Judge, what I can tell you is that Mr. Bettis is under a protective order with his father, and he's been abiding by it. Although there was one minor slip up, his brother actually lived next door to his father, so he goes to his brother's house. He was too close to his father's. But he's very, very much aware of what he can and cannot do, and I think he will comply with the conditions of probation.
All right. So, do you have any prior mental health issues?
May I say it?
Sure.
Before I was incarcerated, my parents, I understand, my mom, me, I was getting in the past. I was getting help at the Center for Healthcare Services for my, like, not that I was on Risperdal, or Risperidone, just for anxiety. But I didn't get to do that before. So that's that.
He was having difficult. He's talking about the day of the incident, Judge. He was having a difficult time.
All right. So, other than anxiety, have you ever been diagnosed with anything else?
No.
All right. When's the first time you saw a doctor for mental health issues?
For 2024, I was saying it was in 2021.
So, how old were you then?
I was 32,
All right.
36.
Drug use.
I've been clean for the last 2 years, please.
Well, whatever. I understand. I'm trying to figure out history here. So, you've been clean for the past 2 years. What have you been clean from?
Alcohol.
And what
drugs.
else? What type of drugs?
I was just smoking marijuana.
All right. So, here's the thing. I'm trying to set conditions for you. I don't do cookie cutter conditions because I want people to be successful. But if you're not honest with me about what you use, what's going to end up happening is you'll be sent off in the world unprepared. And then when you come back to court, which you probably will on a motion to revoke, you're going to want to tell me everything about your life at that point. So it's best that you tell me now. So alcohol, marijuana, what else?
That's it.
Okay. All right. Anything else?
No.
All right. I'm going with the alcohol and marijuana. And so nothing else had better come up in your system.
Yes, ma'am.
All right. The court is finding you guilty. Do you have any children?
I have one son. He's 12.
All right. And who does he live with?
He lives with his mother.
When's the last time you saw him?
3 months ago.
All right.
3 months.
3 months ago. All right. As previously stated, the court is finding you guilty. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. Take in consideration 731618. There's an affirmative finding of family violence.
That's right.
There should be a TAP evaluation. How long is the MIC in custody?
That's probably about a month.
All right. There should be a TAP evaluation in custody and out of custody.
To go through the whole process.
All right. So we'll do a referral to Center for Healthcare Services. If there's some issues with that, Ms. Abrams, then we may have to take it into custody and do the mental health evaluation at that point. So when they give you the referral for Center for Healthcare Services, you had better go.
Yes, ma'am.
Otherwise, what's going to end up happening is you may end up waiting for 30 or 45 days. You understand?
Yeah, Miss Kate, may I say something?
Sure.
That's the first thing I'm gonna do as soon as I'm released.
All right. There should be regular reporting
Yes, ma'am.
by Zoom or in person.
Sure.
The UA hotline
Notice what the judge is doing here. This is a standard but extremely important courtroom safeguard. Before accepting a plea, the court must confirm that the defendant is mentally competent and fully understands the charges. In simple terms, the judge has to make sure this decision is being made knowingly and voluntarily. Without that step, the entire plea could later be challenged in court.
Until further notice. There's to be no contact with Juan Perez.
Yes.
There's to be no unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes those, the community service hours will be deemed satisfied. There should be 90 sober meetings in 90 days. Field visits, one time per month, for 3 months after he has received documentation from Center for Healthcare Services. So once he gets documentation for Center for Healthcare Services, then 3 months for field visits, then as probation deems necessary. There's to be an anger management course, an MRT. When's the last time you had employment?
So, 2023.
So how you been supporting yourself?
I have jobs that are under the table.
All right, so we're not going to do under the table in here, all right? So
I have a job waiting for me as soon as I get out here.
There's-
I'm going to work at the Little Red Bar Steakhouse for the 5th time as a chef there.
all right, so proof of employment within 30 days.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors.
Yes, ma'am.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am. Thank you for understanding and bringing me just like that's
Okay, court reporter is not picking up what you're saying because you're mumbling.
Thank you for everything. Thank you, Your Honor.
All right, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor. Completely understand.
All right, we can go off the record. Here's the thing, to be successful in this court, when you're on probation, communication is key.
Yes,
If
ma'am.
there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court.
Thank you very much.
You're welcome. Good luck to you.
Judge, can we just clarify for him so he'll understand, a TAP evaluation in custody, is that the court's order?
Yes,
So what that means is you have to stay in jail until they come and do the evaluation, and then they'll be released.
yes,
Because the only holding him in the jail right at this point, Judge, is the case that's getting dismissed.
yes. So you'll be in custody. The TAP evaluation, they'll have that done. They're telling me in about 2 weeks, and follow the TAP recommendations. If there's an issue, if TAP recommends inpatient treatment, then your attorney can come back and we can have a discussion about that. All right, is there anything else? All right, thank you. Court is calling 2024 CR 3101B, State of Texas versus Rebecca Jean Alvarez. Can our parties announce for the record, for the state?
Hank Wilkins for the state yard.
Defense?
William Davidson.
All right, and are you Ms. Alvarez? Counsel, have you received all the discovery? Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Alvarez, did you review and sign what's entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes.
Did you review what's entitled True Bill of Indictment with your attorney? Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
We are waiving count 2
Okay, here is the critical turning point. The judge has reviewed the evidence submitted by the state, and this is where the court decides whether there is enough proof to support a guilty finding. Even though there is no live testimony here, written statements and police reports can still carry serious weight in the courtroom.
We're waiving the enhancement allegation, Your Honor.
Any objection?
No objection.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of aggravated robbery? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 18 years in the prison, and the state is opposing your application for deferred adjudication. Did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objections.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, so we can go off the record. I can make a ruling on this if you all will provide me with criminal history, and also I'll give you time to call whatever the witnesses you would like to call. So we can call it back in about 2 weeks if everyone is okay with that.
Well, the issue though is she tells me she has an ongoing heroin problem.
Okay.
I'm gonna request a PAP evaluation just so they can give you something to look at.
All right. Ms. Abrams, TAP evaluation's 2 weeks?
2 to 3 weeks.
All right. Well, I mean, I'll give you a TAP evaluation if you want a TAP evaluation, or if she wants to give testimony about her issues, I'll take those as, I'll listen to her and judge her credibility on whether it's true or not.
We'll go with that, yeah.
All right. So what we'll do then is we'll recall it then in 2 weeks. State, if you'll give me the criminal history, and counsel, if you want to have witnesses present, you can have witnesses present.
Yeah, thank you.
All right. So we can go back on the record. So counsel, you're in agreement then to your calling witnesses in 2 weeks, the state presenting the court with the criminal history. And then if you want her to have testimony of any drug issues that she may have, You're okay with me taking testimony?
Listen carefully to what the judge is saying right here because it is actually a major moment. Judges do not just assign random probation conditions, they tailor them based on a person's history. That is why she is asking detailed questions about alcohol, marijuana, and mental health. The goal is not just punishment, it is to set conditions that prevent the defendant from ending up back in court again.
Testimony on that and then making a decision based upon that as opposed to the full PSI?
Yes, Your Honor.
All right. Ms. Ferguson, if we can recall this in 2 weeks for sentencing. All right. So we'll be back on June 11th. Do you have any questions? All right. So on June 11th, what will happen is both parties will have the information for me. I'll hear whatever testimony and I'll base my decision on your application, of course, on any evidence that's presented to the court. All right. Thank you. Mark Anthony Perez and Ms. Abrams, this is an application. All right, Mr. Menchaca?
Yes, ma'am.
All right, do you have a trial court certification of defendant's rights to appeal? You need to sign it, and then the court will let you know whether or not you have a right to appeal. Do you understand?
Yes, ma'am.
All right, so if you'll sign that, please. And attorneys, if you all will stop checking the boxes on whether or not somebody has a right to appeal, that's my decision. Thank you. All right, court is calling 2020 CR 3565, State of Texas versus Andres Menchaca. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Your Honor, Jeffrey Martinez for defendant.
And are you Mr. Menchaca?
Yes, ma'am.
All right. Mr. Menchaca, did you review the documents entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andres Menchaca who was placed on community supervision in 2020 CR 3565 for the offense of theft on October 13, 2020 for a term of, for the offense of theft 30,000 to 150,000 of a vehicle on October 13, 2020 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5. In Bexar County, Texas, the defendant, Andres Menchaca, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, and December 2023 in violation of condition number 5.
How do you plead to that? True or not true?
Sure.
State.
Okay. In Bexar County, Texas, the defendant, violated condition number 5. In Bexar County, Texas, the defendant, Andres Menchaca, did then and there fail to report to the supervision officer as directed for the month of January 2024 in violation of condition number 5.
And how do you plead to that? True or not true?
Sure, ma'am.
And then on the First Amendment, judge, violated condition number 1, on or about the 27th day of March 2024 in Bexar County, Texas, the defendant, Andres Menchaca, committed the offense of felon possession of firearm in violation of condition number 1.
How do you plead to that? True or not true?
Sure.
Violated condition number 1, on or about the 27th day of March 2024 in Bexar County, Texas, the defendant, Andres Menchaca, committed the offense of possession of a controlled substance, EG1, in violation of condition number 1.
How do you plead to that? True or not true?
Sure.
Violated condition number 5, in Bexar County, Texas, the defendant, Andres Menchaca, did then and there fail to report to a supervision officer as directed for the month of February 2024 in violation of condition number 5.
How do you plead to that? True or not true?
Sure.
Your Honor, I waived the other violations alleged in the motions.
Any objections?
No, Your Honor.
All right, Mr. Menchaca, did you understand by pleading to true to violations 5, 5, 1, 1, and 5, the court could find it true, grant the motion, and sentence you up to 4 years in the prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations of 5, 5, 1, 1, and 5?
Yes, ma'am.
Court will find 5, 5, 1, 1, and 5 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you revoke the defendant and sentence him to 4 years in the prison.
All right, is that the agreement?
It is, Your Honor. It's just also our understanding, this is our third setting for the MTR. First setting we conferred and was given an offer. He also has some other pending cases, Your Honor, that are not in front of you. When we came to the second setting, your first share was all alone, so we didn't have the time to do the paperwork for the
So
additional
is this
cases.
sorry to interrupt, but is this the proposed agreement?
I'm discussing the proposed agreement, Your Honor. I'll be right there. So the proposed agreement is for him to accept the underlying sentence on the MTR, which is 4-year, and then to TIC one of the night mags, and to also run a 4-year concurrent with a felon in possession case that is unindicted, that we need to do a waiver in the paperwork. But we were out of time at the second setting to do that. We're out of time today. So we also need to do.
Come back at 1:30 and do it.
Let's do that. We may.
All right, so this is what the court is going to do. With regards to this case, the court is finding 5, 5, 1, 1, and 5 true. The court will grant the motion to revoke, and we're going to come back with sentencing this afternoon at 1:30.
Thank you, Your Honor.
All right, thank you.
And here comes the sentencing decision. Notice how the judge balances accountability with rehabilitation. Instead of immediate prison time, the sentence is suspended and replaced with probation, counseling, community service, and strict supervision. But make no mistake, probation is not freedom. One mistake could bring this case right back before the court.